Hello, and welcome to HIPAA in 30, effective HIPAA training in just 30 lessons with an introduction to information blocking, the No Surprises Act, and a review of Medicare fraud and abuse. Training is a critical component of your HIPAA requirements. Make sure that all of your staff members not only watch this video, but sign a sign-in sheet showing that they completed it. Now, you have other HIPAA requirements, and we are experts in helping you get those done quickly and affordably, such as your HIPAA risk assessment or your SRA, making sure you've got those policies and procedures up to date, business associate management, contingency and breach planning, and other documentation. Give us a call. We'll be happy to help. Let's get going with our staff training. I am not an attorney, and nothing that we go over today should be construed as legal advice. We are going to be talking about building your culture of compliance, and documentation is key to showing that compliance. Our products do have all of the documentation needed for the HIPAA Security Rule, Privacy Rule, Information Blocking, and No Surprises Act. When we talk about HIPAA, we're talking about federal law. Information blocking and the No Surprises Act also are federal laws that your practice must abide by. Under HIPAA, we have the privacy rule, which goes over the patient's rights, the security rule, the protection of your patient information, and the breach notification rule, reporting breaches. Interoperability is what the government is looking for when it comes to these three laws. We'll talk more about that as we proceed today. Information blocking is a relatively new law. It took effect April 5th of 2021, and it blocks any practice that is likely to interfere with, prevent, or materially discourage access, exchange, or use of electronic protected health information. Whereas HIPAA allowed you to share records with other providers, information blocking requires that you share information with other providers, and if you have a patient portal, push all available information to that portal for immediate patient access. Another new law is the No Surprises Act. Many of you may have heard of this law and think that it applies to hospitals and for emergency care. However, there is a portion for all licensed providers. The good faith estimate must be performed and given to all uninsured and self-pay patients. It is a very specific document that has lots of required elements. So make sure that when you are giving an estimate of charges, it includes all of the required elements that the good faith estimate requires. So under HIPAA, we're protecting what is called PHI, Protected Health Information. It can be oral, written, or electronic. It's basically any individually identifiable health information that relates to the patient's past, present, or future physical or mental condition. EPHI is a subset, which is basically all of the information kept in digital form. SPHI is sensitive protected health information that can cause harm, embarrassment to an individual financially, reputationally, or emotionally. We will talk about special protections for SPHI through this presentation. Under HIPAA, there are permitted disclosures for continuity of care. Remember that under information blocking, now continuity of care requires sharing between providers. But remember that when patient information goes outside of that continuity of care, that we use a proper authorization that has 9 required elements on it. And also make sure that if there are any sensitive protected health information, such as HIV status, that the patient performs a second step to release that information. The minimum necessary standard is the key protection under the HIPAA privacy rule. It basically limits you to only using what information you need for its medically intended purpose. If you're requesting records from another office, only ask for the records you need. Don't ask for the whole chart if you don't need the whole chart. And even though you may have access, it doesn't give you the right to access. You should only access the records, again, you need for your medical purposes, and you should never access your own or friends and family's charts for any purposes outside of medically necessary. A focus of attention for the Office for Civil Rights and Enforcement has been the HIPAA Right of Access Initiative. Patients have a lot of rights under HIPAA. We're going to go over each of them individually. A patient right of access includes getting their entire medical record, what is called the designated record set. This includes all medical notes, all billing notes, all the information that is contained in your EHR. In the past, we only gave patients actual records that our office created. Now, if we have records from other providers or facilities, those must be included as well. We do not have to go out and get additional records, but those records that have been input into our system must be provided. The HIPAA Right of Access Initiative has new charging to patients for copies of their medical records. In most cases, this will override your state allowable. So under the new Access Initiative, we can charge patients either the actual cost or average cost, in both cases using a worksheet to show how we came up with the HIPAA allowable charges. If we don't want to use a worksheet, we can charge a flat fee, which can go up to $6.50, but that must also include postage. So if you're sending a lot of patient records, you're more than likely going to want to use the worksheet because the cost of postage is going to be over the flat fee allowable. Remember that this fee only applies to patients, not attorneys or others requesting patient records. As you can see from this government chart, patients have the right to request their records in whatever format is convenient for them and whatever method they choose, either in person, via email, they can mail you the request, fax you the request, or call it in, which means we must have verification procedures to determine that the patient is actually the patient. Once we receive the request, again, the patient has a right to get those records in digital format, which could include email, or they can still get their records via paper. Of course, the easiest and best way to deliver patient records is through the patient portal. Now, if we have a portal, information blocking takes effect, and we should be pushing all available information immediately to that patient portal. The privacy rule requires that you provide the individual with their medical records in the form and format they requested, which now includes digital. Most common, you are going to get a request to put records on a CD, thumb drive, or email. Now, if your practice no longer has a CD burner, you do not have to go out and purchase one. But all practices are expected to have email, and most computers do have thumb drives. Understand that you cannot put a patient's thumb drive into your computer to transfer their records. You must purchase and resell that thumb drive with the medical records to the patient. We recommend a flat fee of $25 for this to cover your cost. Now, for email, we have special requirements. When we send a patient their medical records via email, we must either encrypt that email or notify the patient that there is a chance that these records could be seen or intercepted, and do they accept that risk? If so, the email notice and warning on the right side of your screen must be included in that email. The patient does not have to sign off on it, but we must state in the email that we warned the patient and the patient accepted the risk. You could send them an encrypted email, but expect phone calls. What's the password I need to use? How do I set this up? How do I view this email? Many times it's easier to send it unencrypted with the warning than to encrypt it and have the patient go through the unencryption process. However, understand that the only time you can send unencrypted email with patient information is directly to the patient at their request with this notice given. All other emails with patient information must be encrypted. As we showed you on the chart earlier, that patients have a right to call in their request for medical records. Your office is no longer allowed to require the patient to come to your office and sign an authorization form to get release of medical records to themselves. So you must have a form of verification, and you must document that you verified who the patient was. Now, you cannot use unreasonable methods. I can't say what's your grandchild's middle name, but I can ask questions such as what's your date of birth and what's your home address. Yes, you can, and at times may be fooled by somebody who knows that information. But again, document that you requested that. I like using the initials VID for verified identity. The HIPAA right of access is not only for patients to get copies of their medical record in both paper and digital form, but also to inspect their records. This right allows patients to come into your office, sit down, and review their medical records on your computer system so that they see the medical records the same way that you see the medical records in your office. Now, like with all requests, you have up to 30 days under HIPAA. I am going to mention that there's a proposed rule that we expect to go into place approximately in October that will reduce that 30 days down to 15 days. But currently, under the standards, you have the full 30 days. Not only to give them access to inspect their records, but also for providing them with copies of their medical records as well. Under the new information blocking rules, we can only deny access to patients or other continuity of care providers if it meets one of these 6 provided exceptions. It is meant to be rare, and it must be documented on a case-by-case basis. The form you see on the right includes all the specifics for the privacy exception. Each exception has its own form, and again, must be fully documented before you block access to a patient or another continuity of care provider. Under the HIPAA privacy rule, patients have a right to request that you amend their medical record. This is a right to amend and not correct. We always want to keep the record accurate and correct. So if the patient is correct with their request, we would, of course, make that amendment. But otherwise, we are going to keep the record accurate and correct. If we deny their request to amend, we must send them a letter letting them know the reasons for the denial. You have a right to contact your patients to give them appointment reminders or let them know that test results are in. Now, when we leave information, we should again apply minimum necessary and only leave the time and location information or other information that is necessary for them to call back. If patients request confidential communications, we should respect their request. So perhaps they ask you to only send information to their work address or only to call them on their cell phone. Patients also have a right to request restrictions of who you share their information with. Now, it is reviewable if they ask you not to share information, say, with their previous physician. Perhaps that physician is no longer a part of their continuity of care providers, so they've asked you not to share information. That we should probably respect. However, patients do have a right to restrict information going to their health plan for payments made in full. This does not apply to Medicare or Medicaid or any other federally program, but if I have commercial insurance and ask you to not file this claim because I'm paying for it out of pocket, that is my absolute right under HIPAA. A common misunderstanding under HIPAA is what we can and cannot discuss with family and friends. We are allowed to discuss patient information with family and friends when it is in the patient's best interest. This is not a free-for-all to go into all of their information, and we should always ask permission from the patient first, or discuss the information with the patient present so that if they decide that they don't want this person to know, they have the opportunity to object. Use your professional judgment. Again, this is not a free-for-all to go into all of the patient's information, but if we're discharging a patient after a procedure, we can give that information. If we've got a caregiver that has driven the patient to our facility, and we want to make sure that they understand that what instructions this patient needs to follow to get better, we have that ability to do so under HIPAA. Patients have a right to an accounting of disclosures, finding out where you've sent their medical records for the past 6 years. Now, the good news is that you do not have to account for continuity of care or that treatment, payment, and healthcare operations. So these are things outside the normal, such as court subpoenas or maybe reporting the patient's condition to the CDC. Patients are allowed one accounting of disclosures every year at no charge. Your office must maintain and abide by your notice of privacy practices. It must be posted in your lobby, and if you have a website, on the homepage of your website as well. Make sure that all patients sign that they've had the opportunity to receive. If they do not sign, just mark it as such and note that you gave them the opportunity to. The important thing about a notice of privacy practices is that it lists the patient's rights and it tells them that if they do file a complaint, our office is not allowed to retaliate against them. Now I'd like to turn our attention to the HIPAA security rule. Healthcare cybersecurity. We have seen a 45% surge in the increase of cyber attacks since COVID began. Health records are a primary target of the cyber criminals, and you need to be aware of the way that we can protect our records. Security is everyone's responsibility, and now, more important than ever, you should think before you click. Think before you click on an attachment or a hyperlink, or even just responding to a request for information. Other important factors in healthcare cybersecurity include never disabling your security controls, such as turning off antivirus or disconnecting your firewall. Do not install screensavers or other programs, as they could put malicious software on your computer. Never again bring in a thumb drive from home or accept a patient's thumb drive, as they could have malicious files that can transfer onto your network. And never leave your web browser open or go to unauthorized websites while you're at the office. Use your common sense. Trust your gut feeling. If it feels too good to be true, it probably is. You probably did not win a $50 Amazon gift card. So stop and think what is being asked for you, and think about, again, how did they come up with my email address? Why did they get my information? Why was this sent to me? So healthcare records are a primary target because of the value of those records. We've seen that they are now being used for ransomware, Medicare fraud. We've seen what's called the banking virus, where they get onto your network and redirect payday from you to themselves. They have been known to exfiltrate or steal these patient records and put them on the dark web for sale, or use them and call your patients directly to extort them. Identity theft, crypto mining. There's lots of ways that criminals can use the information in your medical records. So always be aware that they are always using new and improved social engineering tactics, such as being an authority figure, consistency, validation, different ways that they make you trust them into giving information that they shouldn't have. Phishing emails are the #1 tool of the cyber criminal. They're cheap and effective. They estimate that as many as 1 billion social engineering emails go out every single day that contain malicious software. So look before you click. Does the email have a sense of urgency to it? Does it request personal or practice information? Does it ask you to verify your account? Does it include a generic salutation? Or does it tell you that you've won a prize? Or does it ask you to complete a survey to win something? Lately, we've also seen an increase in the number of junk emails that ask you to unsubscribe, and by clicking on unsubscribe, you actually unleash malicious software onto your computer. And look at it. Does it look right? Does it sound right? Phishing emails, again, are easy for you to review and understand that they're not coming from somewhere that you should click on. We'll go over some of the methods to use. Here we have a phishing email with a sense of urgency. Your account has been suspended and you need to click on this PDF. No, let's look at it. It states it's coming from Bank of America Business, but when I look in the parentheses, what is the real email address? I see grouppharma@grouppharma.com.ec. Quite a few things you should notice here. So always look at the return email address. Grouppharma@grouppharma.com.ec is not what I expect. I expect to see bankofamerica.com. I also see two initials after the .com. Those two initials are a country code. This email is being redirected to Ecuador. So always look at the return email address and make sure that it matches who the email is being sent from. In this phishing email, we see the importance of not multitasking while we're opening up our email. If I look closely, I see notifications to at verizon.com. But again, I always want you to look at the email in the parentheses because that's the real email address. ventas@gasq.com.mx. So again, a couple things here. One is a longtime Verizon customer. I know it's verizon.net, not verizon.com. But again, I'm also seeing that it's not going to verizon.net or even verizon.com. It's going to gasq.com.mx. This is being redirected to Mexico. I do want to point out that a lot of times to make their email look more legitimate, they put a customer support 800 number. If you call that number, you're going to find it's not going to go to the Verizon team. Here's another phishing email with that sense of urgency. Notification. You are not receiving your email messages. Click here to release them. No, let's look at that return email address. fmw@school.hk. I use a company called iPage, so I would expect to see ipage.com. So again, either delete or leave this email alone. Using complex passwords is a critical component of your security, both for at work and at home. Cyber criminals use two types of password attacks, one known as a brute force attack and the other is a dictionary attack. And if you're not using a complex password, you are very susceptible to these attacks. So what is that complex password? Well, 12 characters in length minimum, upper and lower case letters, 2 numbers, and a symbol. Using a complex password will help to protect your accounts. And we need to protect not only your login to your computer at work, but we also need to have a complex password for our EMR and practice management systems. And make sure you're using a complex password to access your email. Email has been a favorite target of the cyber criminals because once they get onto your email, they can learn a lot of information about you and send an email from your account to another unsuspecting employee who will click on a link and give them access to your network. I also want to point out that a practice had a weak password policy or no password policy. They got a fine of $600,000 after their network was breached due to those weak passwords. At work, we must restrict our internet usage to work purposes only. Going to the insurance companies to do verification, checking on doing Googles of doctor searches, looking for their phone number and address. Those type of things are acceptable. But the internet is a very dangerous place, and therefore we want to avoid shopping websites, celebrity websites, social media, sports websites, and especially your own personal emails. Going to your own Gmail or Yahoo or other free account is extremely dangerous because if you click on a malicious email, the network that you're on is the one that's going to get infected. Do understand that there are reviews of your access on the internet, and that you are held liable. Again, your user ID, your password that you're using, is your digital fingerprint and can be used to track where you go on the internet. So think before you click and think before you send an email. Again, as we stated earlier, you can send an unencrypted email with patient information directly to the patient after they've been warned. But otherwise, all other email with patient information, whether it's going to another physician's office, whether it's going to the insurance company, it must be encrypted. So many of you are probably thinking, why do I get so many emails from other practices that are not encrypted with patient information? Well, not everybody's HIPAA compliant, but our office is. Breaches happen, and there is a HIPAA federal breach notification rule that requires us to document all breaches and in many cases report them to the patient and to the Office for Civil Rights. In fact, the only items that our office is required to report to the Office for Civil Rights at the end of the year is the breaches that we have suffered in our office. Now, breaches don't happen that often, and you may think that some of them are too small to report, but there is no breach too small to report to your HIPAA compliance officer. Common breaches are things such as misdirected communications. Perhaps we send medical records of a patient to the wrong physician's office, or we give patients another patient's test results or prescriptions, or we attach files to the wrong patient record. Even scanning patient records into the wrong chart is a breach that we must report to our HIPAA compliance officer. Employee snooping is definitely a reportable breach. And improper disposal. Don't forget that paper. Maybe it's just a post-it note. If it's got patient information on it, it must go into the shred bin, not to the trash bin. If you experience a breach or even suspect that you may have had a breach, we must document it. It is federal law that the 4 questions we see here are documented and given to your HIPAA compliance officer. So basically, what was the PHI that was on the document or forms? And who was the unauthorized person that saw it? Was it actually viewed or acquired? Well, perhaps if we scanned it into the wrong patient's chart, that patient may or may not have gone to their patient portal. Either way, we are going to document it and again, give that to our HIPAA compliance officer. And what have we done to mitigate any harm? Well, if I send it to the wrong doctor's office, I'm going to ask them to shred it and then get it to the correct office. A lot of breaches will occur in your office as patients overhear other patient information or see information on a computer screen that is not theirs. In these cases, it's typically incidental information, and as long as it was due to a proper disclosure, we're not going to have to fill out a breach report. So if I am telling the doctor outside the room of a patient's condition and another patient overhears it, that is incidental to a proper disclosure and therefore falls under incidental disclosure. Always use a clean desk policy at your office. That means that if I've got paper or computer screen up, if I don't need that information anymore, I should take that information off my computer screen. If it's paper, I should cover it up, turn it over so that other people cannot see that information. Before we conclude our training today, we want to talk a little bit about Medicare fraud and abuse. Medicare fraud is a tremendous problem in the United States. Now, there are different definitions for fraud and abuse. Medicare fraud is when you knowingly submit false statements or make misrepresentations to get payment, or accepting different enumerations for referrals or other services, or making prohibited referrals. Another example of Medicare fraud would be upcoding or charging for a more complex service than what was actually performed. Medicare abuse is any practice that is not consistent with the goals of providing patients with services that are medically necessary, meet professionally recognized standards, and are fairly priced. So again, we want to be part of the solution and not part of the problem. Federal laws governing Medicare fraud and abuse include the False Claims Act, the Anti-Kickback Statutes, Physician Self-Referral Law, Social Security Act, and the United States Criminal Code. Do understand, Medicare abuse can also expose providers and individuals to criminal and civil penalties. It is the Office of the Inspector General that enforces the Medicare fraud and abuse standards. And on our slide here, we have listed the CMS hotline for you to report any suspected fraud or abuse. Another new law is the requirement to report to the Cybersecurity and Infrastructure Security Agency, or CISA, any cyber activity that occurs within your office, such as unauthorized access or denial of access to your websites, any malicious code that gets onto your systems. Make sure that you review the 10 key elements and contact CISA at the number or email below to report any of these intrusions onto your network. This is now a requirement under federal law, and you must report within 3 days any intrusions, and if you pay ransomware payment, that must be reported to the Cybersecurity and Infrastructure Agency within 24 hours. So when it comes to HIPAA and security, we want to balance privacy with good health care. And we should always err on providing good health care to our patients. If you have a question, get with your HIPAA compliance officer and review it so that you are doing the best for your patients and abiding by HIPAA and the other regulations. Before we conclude today, 2 reminders. 1, there is a set of proposed rules for HIPAA changes that are currently out there and may go into effect later this year, so keep an eye out for those. 2, if it's not documented, it's not done. HIPAA, information blocking, the No Surprises Act, there are lots of requirements to these rules. Make sure you have the forms and documentation to document your compliance. Thank you for your time today. We sincerely hope that you learned a lot about your rights as a patient and how to protect yourself and your practice when you are online. Now, we highly recommend that you hire us for your full HIPAA compliance services. We have very affordable plans and do it in a proven manner to reduce the amount of time you have to spend on your compliance. Give us a call. We're here to help. 813-285-1944. If you enjoyed this video and want to use it, please do. Also, like us and put comments, and make sure that you check the link to our Facebook page for updates and further contact information.